speeding 20 to 24 miles over the speed limit. The officer who wrote the citation is here. He'll be testifying about the circumstances under which the citation was issued. You'll have a chance to ask him any questions about his testimony and then testify on your own behalf if you choose to. You are not required to testify, but if you do choose to testify, then I could ask you questions. If you have any serious prior criminal history that happens to come out, that could be held against you as far as your credibility is concerned. Discovery is not available until the day of the final hearing, which is today, and so the officer is going to show you the notes that he has on the back of the ticket and that he's going to be using in his testimony. If you have any questions, any procedural questions, I'm happy to try to answer them for you if I can. I cannot give you any legal advice. Did you want to look at the notes?
I think I've already seen those notes, and it's...
Okay, go ahead and pause it. All right, so here she basically lays the groundwork for how this hearing is going to go. She's calling it the final hearing. Now, there's a lot of issues with this that I would have brought out as soon as he had the moment to speak. She asks him a question about the notes and if he wants to look at them, and he felt an obligation to answer her question. Well, so what she did was she laid the groundwork. Basically, it's like a computer program. She writes the code. This is how it's going to be, and then asks him a question. And if he had taken that opportunity to point out, well, wait a minute, I'm only now just getting to look at the evidence. I'm only now able to, review the discovery. How is that justice? Don't I have the right to a fair and meaningful hearing? So don't I have the right to review the evidence that is going to be used against me without having to rush to judgment before this trial begins? Obviously, it's an administrative hearing, so they're trying to just use their own little rules for it. But he could object to that rather than to answer her question and begin to participate. So go ahead and.
So, did you want to look at the notes?
I think I've already seen those notes, it's in the discovery request. There was actually more items requested, and
okay, so you don't get discovery in these cases until the day of, and discovery consists, unless there's something else, officer, of the notes on the back of the ticket, which I don't imagine you would have.
Yeah, so objection, point of clarification. I don't have the opportunity to determine whether or not I'm going to need counsel for this hearing before you begin the hearing. I don't have any time to review the evidence that is being alleged in these accusations, and I don't have the right to be informed of the cause and nature of these accusations and proceedings before we begin what amounts to a trial. How is that fair and meaningful? If you guys have any questions too, or feel like there's something that can be elaborated on, go ahead and let me know. But go ahead.
Because it's not on your copy of the ticket, but it's on the officer's copy of the ticket, any notes that he made. Okay. Any questions, Mr. Nesbitt?
Yeah, I just had some clarifications.
Okay.
So my intention today is to plead guilty.
Okay, so go ahead and pause.
Do I have a right to plead guilty here today?
So she just asked him if he has any questions, and he said, yeah, I just have some clarifications. So his answer to do you have any questions is yes. So now, even though he qualified his statement with that he's going to be making clarifications, he has admitted that the things that he is actually asking are questions. And of course, there's a distinction between those two things. It may not matter so much since this sounds like more of an administrative type hearing. But, we know that these administrative type hearings have very real consequences. So He should be a little more careful about how he responds, because questions and clarifications are not the same. And if she's going to ask him if he has questions and he's going to say yeah, now it's clear for the record that the things that he is asking are in fact questions. Go ahead.
Do I have a right to plead guilty here today?
If you'd like to plead guilty and withdraw your not guilty plea and plead guilty, then it would be 6 points and a fine. That would be the sentence.
Is this proceeding being recorded here today?
It is.
It is being recorded. Okay. How do I get access to that?
All right. So she just said, in response to his question, she didn't answer his question. He asked, "Do I have the right to plead guilty here today?" And instead of answering his question, she said, "If you want to plead guilty, then yada yada yada." And she slipped in there the requirement to we can withdraw the not guilty plea and enter a guilty plea. And he did not immediately object to the fact that a not guilty plea was entered against his will, that it was never a knowing involuntary plea, because that's part of what they're hanging their hat on. That's how they are proceeding with this right now, is by claiming that he entered a not guilty plea. So now, once they say he entered that not guilty plea, now he's bound by the rules, which happens to be, well, you don't get any of your discovery until final hearing. This is the final hearing. This is how it's going to go. These are the rules, et cetera, et cetera. So for him to completely abandon a really good opportunity to point out, well, wait a minute, objection. I never entered a not guilty plea. Do I have the right to enter a not guilty plea in the first place? Before you misconstrue that I have entered a not guilty plea. So it was her way of kind of slipping that on the record, and he didn't object to it. He went to talk about whether or not the hearing was recorded, which is a good thing to know, but definitely not pertinent in this situation. Not in that moment, anyway. Go ahead.
How do I get access to that?
Okay, so first let's figure out what you're going to do, what you want to do today. Do you want to proceed with the final hearing, or do you want to withdraw the not guilty plea that you entered and enter a plea of guilty?
Okay, well, go ahead and pause that. So this is a common tactic that judges use. She asks, do you want to do this thing, or do you want to do this thing? And the end of that sentence ends with a question mark. So she could have asked, do you want to drink lemonade, or do you want to drink milk? Now, one of the options may be to drink a glass of water, or one of the options may be to drink a glass of Kool-Aid. But her tone asks the question as though there are only two options that exist in that moment. Whereas the question itself, when read on a transcript, it's going to ask if he just wants to do one of those two things. So keep in mind that when you're listening to a judge speak, they use their tone, they use the way they formulate the sentence against you. So when they ask, do you want to do this, or do you want to do this? The way the voice goes up and then the way the voice goes down, it shows the person that is listening to it that those are the only two options they have, when that may not be true at all. Go ahead.
Well, I just wanted to get some clarification before I can enter that plea.
Okay, you've already entered a plea.
Well, I actually did not enter a plea. It was entered for the benefit of the plaintiff.
Okay, well, you're the plaintiff in this case. Okay.
Am I not the defendant?
You're the defendant. I'm sorry. It was entered for the. I thought you meant yourself. Okay.
Pause. So right there, that was a big trick. It's debatable whether or not she meant to say that slip up. But the end result is it tricked him into confessing that he is the defendant. Once he confesses that he is the defendant, then in their eyes, he's agreeing to participate in their game. So had he, and it wasn't most effective to say that the not guilty plea was entered on the prosecution's behalf, or it was entered for the plaintiff. What would have been most effective to say is it was entered against his will, and seems to have been entered by the judge against his will to alleviate the prosecution of their burden. And then, of course, asking, well, aren't I the defendant? Big mistake. He could have said, well, aren't you alleging that I'm the defendant? Something like that, but I wouldn't have. I would have said something like, well, it's questionable that I am a plaintiff or a defendant, because I have yet to see any evidence that I have an obligation to participate in this whole thing. So are you alleging that I am, in fact, a defendant in this matter? Would have been a good question where you could have gotten her to make some confessions. Go ahead.
I thought you meant yourself. Okay. So what do you want to do, Mr. Nesbitt?
I just had some clarification.
Okay. What clarification?
Yeah. Do I have a right to be informed of the cause and nature of the proceedings today?
You've already been informed. You're here for the final hearing. You've already been advised.
I actually have not been advised
You've
since.
been advised, Mr. Nesbitt. Do you want to proceed to the final hearing, or do you
Okay, go ahead.
want...
Pause. So there she changes it to you've been advised. Okay, and then he makes the claim, I have not been advised. Well, how does he know that? She's speaking legalese. Advised to her has a distinct legal definition, and instead of talking about whether or not he's been informed of the cause and nature of the accusations and proceedings, and notice that he forgot to say accusations. I think it's important to also be informed of the accusations as well as the proceedings. And she just turned it around. Well, you have been advised, and then which makes him say, I have not been advised. So that's another psychological manipulation that judges do, is you ask, well, can't I be informed of this? And they say, well, you've been advised. And they're making it seem as though the word advised and the word informed are interchangeable. And if they can get you to, accept the word advise being interchangeable with informed, then they know that, oh, this person has a weakness, and that they'll take advantage of that. So here you're probably going to see her take advantage of that weakness. Go ahead.
Do you want to withdraw that plea that you entered and enter a plea of guilty and have a sentence imposed? Those are your options this morning.
Are there any offers available on the table today?
No.
Okay, go ahead and pause. So once again, she slipped onto the record the not guilty plea that you entered. So she slips onto the record these things, and if he doesn't object to it, if he doesn't say anything about the fact that she's doing that, then she just knows that she can keep doing it. And now, well, we were talking about the not guilty plea that he entered. If he didn't think he entered it, then why did he allow me to get away with saying that? That then becomes the argument. That then becomes a not to unravel. So, he has to become more cognizant and listen carefully to everything that the judge is saying. And I know he's new and his mind is racing and all that, but just to point out, this is what you've got to be able to do, is hear every word that the judge is saying, and don't let them put lies on the record, or don't let them put false confessions on the record. Get them to make confessions. Don't allow them to straw man your position and mislead the transcript. And when you catch them doing that, there's no reason why you shouldn't just point out, oh, whoa, I already told you that I didn't enter that not guilty plea. So are you attempting to slip that in so that it will read on the transcript? Because if I don't notice that, then it'll seem as though I'm agreeing that I was the one that entered the not guilty plea. You point out a judge's tactics like that, and they'll have to stop using them. Go ahead.
No, I think you were advised the last time you were here that any offer that might have been on the ticket, which, let me see, there may not have been one because it's a 6-point charge, and usually that's a mandatory court appearance. Yeah, mandatory court appearance, so there was no offer. You came to evening court, and there was probably some kind of an offer that the magistrate conveyed to you at that time, and
let's pause here. So you notice that it's a magistrate, not a judge. That's another indication that this is just a, private company that is basically handling this type of thing and extorting him. She brings up the mandatory court appearance. I would be inclined to say, oh yeah, by the way, let's talk about that, this mandatory court appearance. This is why it's important to lay the foundation in the beginning that, what will happen if I don't show up, because somewhere in that, if I don't show up, even though in this situation it probably wouldn't have been a warrant issued for his arrest, it would have been some kind of sanction against him or financial injury that he could point out and say, well, the only reason that I've shown up is to mitigate the threat of violence against me. So, bringing up the gun in the room is important because it shows further that this is not something that you're agreeing to. You're still requiring their evidence that they have the authority to do this and that you have an obligation to them. So, bringing that out on the transcript and having a discussion about that is the only way that you're going to really be effective. Go ahead.
You chose not to accept that. Let me just see.
So, Your Honor, I still have not been informed of the cause and nature, considering the plea was entered by the previous judge.
Okay, I don't know what you're talking about, Mr. Nesbitt. I've given you your options this morning, so you can withdraw the not guilty plea and plead guilty, or we can proceed to final hearing. Those are your choices.
Go ahead and pause it. So how is it that you don't know what I'm talking about when I've already informed you that I never entered a not guilty plea? Why do you continue to proceed as though I entered a not guilty plea? You do know what I'm talking about. Are you trying to tell me that you don't know what I'm talking about so that you can try to make this all seem as though it's a voluntary thing? Where is your evidence that I have an obligation to obey and follow your orders? And Appender, I've noticed, has frequently said Your Honor in all of the role plays, et cetera, and I think I've told him about this. Don't call them Your Honor. Take that completely out of your vocabulary, because continuing to call them Your Honor is just, it's believing in the delusion. So that's only going to hold you back. But go ahead.
Would it be possible to have a judge instead of a magistrate?
No, not possible. Well, let's see. No, not possible. This is a traffic infraction. You don't have a choice. You're not entitled to a jury trial, nor are you entitled to a judge.
So is this a hearing or is this a trial today?
This is what's called a final hearing.
Okay, so is it a trial or is it a hearing?
It's similar to a trial, Mr. Nesbitt, but there's no attorney.
All right, so this is why I caution people. Be careful of legalese. This is a final hearing. It is titled final hearing. It is a proceeding, a type of proceeding that they have written within their legal system. So people have to consider that when you have these little administrative type hearings, it's basically a mini legal system that has been created, and they just expect that people are going to agree with it and never challenge it. This isn't a hearing that, where the people in it are bound by the Constitution and, there's all this America stuff and all of that. It's not like that. This is a private company that is holding what they call a final hearing, making people believe that they have an obligation to go and pay them money if they deem it necessary for them to receive money. So if you don't challenge this notion, then it's going to be hard. And this isn't like something that is like, oh, I want to appeal it now and appeal it to the Supreme Court. The appeal will happen within their little legal system that they have created, and they have a process for it. So don't be surprised when things like this don't go very far. And you need to point to the fact that they're pretending that you are doing this voluntarily. And you can see her, you can hear in her words how she's trying to hide that fact from him, hoping that he won't see what is obviously right there in front of his face, because it's a hard thing to see. If you're not trained to see things as they really are, it's very easy to think, oh, well, this is why is this a magistrate instead of a judge? How come I can't have a judge? Well, it's because these are the rules within their mini legal system that they have created to extort you of your money. So be careful of that. Go ahead.
You're not entitled to a jury trial, nor are you entitled to a judge.
So is this a hearing or is this a trial today?
This is what's called a final hearing.
Okay, so is it a trial or is it a hearing?
It's similar to a trial, Mr. Nesbitt, but there's no city attorney prosecuting the case. It's just the officer.
Okay.
He testifies about the circumstances under which the citation was issued, and as I explained to you, he has you have a right to ask him any questions and then present a case of your own if you choose to. And then at the end of the final hearing, I'll take a few minutes, review my notes, and give you a decision. If you're found guilty, it's 6 points and a fine. If you're found not guilty, no points, no fine. Okay, you ready to proceed?
Well, it seems like I'm being forced to proceed.
You're not being forced to proceed. I gave you your options.
Yeah, so there is nothing there that shows that he's being forced to proceed. You can't say that you're being forced to proceed unless there's a threat of violence. If you have not gotten a threat of violence on the record, then there is no force. What happened here is he was persuaded to proceed. She asked him, "Are you ready to proceed?" And he thought, well, I'll preserve the record and say, well, I feel forced to proceed. And then, of course, she responds to that with the truth, which is, you are not being forced to proceed. She wasn't lying. She was being completely honest. And she tore apart his entire argument with that one sentence. If he had come back with something that actually showed that he was being forced, then that would have been something that she would have had to respond to. But he didn't, I don't think. And so, don't just think that you can say, well, I'm being forced to, so I guess I will. Unless there's actual force that you can point to, you are not being forced. You're being persuaded. And you've got to learn that distinction. Go ahead.
You're not being forced to proceed. I gave you your options, so if you are ready to...
And I've already explained that. I already filed the motions explaining
those motions
to strike the plea from the previous judge.
Those motions have already been ruled on, so we're going to proceed today.
What are the
unless-
grounds for those rulings against to strike the plea from the previous judge?
I don't know what you're talking about as far as strike the plea.
To vacate the plea. Excuse me.
You don't have that. You have the right to vacate the plea and plead guilty. And then
Okay, let's go ahead and pause. So she doesn't know what he means by strike the plea, because strike the plea is not a phrase that is within her legalese. That's not within her rules that she operates under. So, then he changed it to something that is within her legal system. Vacate the plea. But the problem with vacate the plea is you can vacate a plea that you voluntarily entered. So he needs to point out that he's vacating a plea that he did not voluntarily enter. I mean, he should be cautioned not to speak legalese in the first place. So he changed to a legalese phrase that he thought meant the same thing as strike the plea, but doesn't. And all he had to do was explain in common English, explain as though you're talking to a 5-year-old, what you mean. The plea was not entered on my behalf. Don't I have the right to enter a plea in the first place? Don't I have the right to enter a not guilty plea in the first place, Judge, before you force me to come into this final hearing? Why was a plea entered against my will? And then she says, I don't know what you're talking about, because she wasn't the judge that ruled on any of the motions. So he should be pointing out, well, are you going to assist in a great injustice that has happened? I'm the only person that is in this room right now who was there that day. And I am informing you that an error has been made. A not guilty plea was entered against my will, and it alleviated the prosecution of their burden. And it was so that the judge would alleviate that prosecutor's burden. So why aren't you going to help me hold this judge accountable for the violation of due process? Something like that. Point out to her obligation to stop corruption, because she is obligated to prevent things like prosecutorial misconduct if she sees it. And if a judge is assisting with prosecutorial misconduct, then she would also be obligated to correct everything that judge did, file a complaint against him, let her superiors know what he did, and make sure that he never does that again. That's supposed to be her role. So pointing to that will get you a lot further than just giving up after she says something. So go ahead.
And then I'll impose a sentence.
No,
I don't know what
I
you
think
mean.
I'm being forced
Okay, Mr. Nesbitt,
in a different direction.
What do you want to do?
I would like to make an informed decision going forward.
Okay, so...
Does this court accept involuntary and uninformed pleas?
Go ahead and pause. What do you want to do? I want to be left alone and never bothered again. You're going to ask me what I want to do? I would like I want to be able to walk out of here without ever having anybody extort me again. I never want to see your face. I never want to receive any more letters. I never want you to threaten me again. I want to walk out of here left alone. That's what I want. So, do you have any evidence that I have an obligation to be here? Or are you committing a crime by proceeding in this manner, pretending you don't know what I'm talking about, and not dismissing the case or this alleged case like you're supposed to? Show me the evidence or leave me alone. That's what I would like to do, Judge. Go ahead.
Mr. Nesbitt, I'm going to give you one last opportunity to either proceed or withdraw the plea, and I will impose a sentence. The third option is for me to hold you in contempt of court, which I don't want to do, but if you don't want to cooperate and you don't want to proceed and you don't want to not proceed, then I won't have any option but to do that. So what do you want to do, Mr. Nesbitt?
I would like to make an informed guilty plea.
Go ahead and pause there. So she just said, and I don't know if she was just sloppy or what, but she just said, your third option is hold you in contempt. Your first option is you can want to proceed, or you can want to not proceed. Or I think she phrased it in the negative. You're here and I can't tell if you don't want to proceed or if you don't want to not proceed. Don't want to. Well, I guess those are the same thing, aren't they? So she basically said, she was redundant. So she said she didn't even allow not wanting to proceed as one of the options. It was you want to proceed or you want to proceed, or your third option is contempt. So it was pretty tricky language there, but he allowed it to bamboozle him there, it sounds like. Go ahead.
That's still on the table for me.
Guilty plea.
An informed guilty plea here today.
So.
And I feel like I'm still uninformed.
The record. What do you want to be informed about? What do you mean by informed? Exactly what do you mean by informed? So I can inform you.
I just had some clarifications that I would like
Go ahead
to.
And pause here. So this is something that happens a lot, and it's really interesting because it shows that what we are doing is on the right path. Because she is literally giving him mic time now to say what he wants to be informed about. Where if what he was saying was not important, and if she was just going to bulldoze him anyway, then she wouldn't be allowing him this time to speak. She knows that he is still saying that he has not been informed, and so now, in order to make sure that everything is clean and tidy, she is asking him, what do you want to be informed about? And she probably knows that his response is going to be weak because she's been probing him for weaknesses and finding them. So she's very comfortable now just letting him say what he wants to be informed of, and she's probably hoping he'll make a mistake. So go ahead and let's hear if he does.
What do you want to be informed about? What do you mean by informed? Exactly what do you mean by informed? So I can inform you.
I just had some clarifications that I would like to just field to the court and get some honest responses.
Okay, so that should have happened when you entered before you...
Go ahead and pause. Yeah, so here he had a chance to say exactly what he wanted to be informed about. She asked him very directly, and he says, I just want to ask some clarifications and get honest responses. Why? That's like that's like a girl holding out her lips for you to kiss her and you saying, I want to just kiss you right now. It's, do the thing, ask, respond. She just gave you the opportunity to let her know what information it is that you are seeking, and you just stood there and did nothing. And now she uses that as an opportunity to say, well, that should have been done a long time ago. Go ahead.
Before you entered your plea.
And I already said I did not enter a not guilty plea.
That was already ruled on, and it's been found that you did.
On what
enter.
basis was it found that I did
Okay,
not?
Mr. Nesbitt, you're being argumentative and just
Go ahead and pause. So, here she's stopping him from being effective, but he's also allowing her to stop him from being effective. She said that's already been ruled upon. Well, what do you mean by that has already been ruled upon? I'm bringing this up right here, right now. I never entered a not guilty plea. Do I have the right to enter a not guilty plea or not? And have her answer it. Hold her to that. This is what I need to be informed of. Do I have the right to enter a not guilty plea in the first place? Okay, we've established that I have the right to enter a guilty plea, but you keep on pretending as though I've entered a not guilty plea, and I have not. So do I have the right to enter a not guilty plea? Voluntarily, informed. Don't let her trip you up by saying, oh, that, being vague, that has already been ruled on. What has already been ruled on? This issue that I'm bringing to the table right now? Or are you talking about the motion that you're saying has already been ruled on? It's precise language. If you're going to do this, you've got to listen to the exact words that are being said, not form any assumptions about what is being said, and point to the things that they are saying, the exact words that they are saying, not what you think they are telling you, but what they are actually saying. Go ahead.
I've given you your
Objection,
options.
Your Honor.
You can either proceed
Is trying to see clarification
I've given you all
being disrespectful?
Okay. Call the sheriff, please.
Okay, so here's the threat of violence. Call the sheriff, please. We got to get the gun in the room now. Is seeking clarification respectful? Now, granted, he shouldn't. That's a good question, but it's not as though he's actually seeking clarification, because he's not telling her what he wants to be informed about. If there's no clarification on the table, then she can say that he's just being disruptive, and she can threaten him with violence. If when she asked him, what would you like to be informed of, he had come up with the very last clarification that has been on the table and unanswered this whole time, then that would have been a different story. Then you're basically getting back to arraignment. But he doesn't do that in this case, and she uses that against him. Go ahead.
Okay, so the record should reflect that the court's authority to act in this case is vested in this court pursuant to Article 6 of the Colorado Constitution, Sections 1 and 16, and the Colorado Revised Statute, Section 13-6-104. The court has subject matter jurisdiction pursuant to Article 6 of the Colorado Constitution, and Colorado Revised Statute, Sections 13-6-103 and 104. The court has personal jurisdiction as a result of service of the summons complaint on the defendant in accordance with Rule 304 of the Colorado Rules of Civil Procedure. The court notes that Mr. Nesbitt appears to not want to proceed, appears to not want to plead guilty until he gets what he calls an informed information about.
Go ahead and pause. All right, so here she lays out all of the rules as to why she believes that she has subject matter jurisdiction and personam jurisdiction, or she called it personal jurisdiction. And so this should be a big red flag to anybody who is listening to this, because the point that he is making, not making. He's making this point in his head. He's not articulating it very well, but he's making the point that they have yet to show how they have what is considered to be personal jurisdiction against him. So now she just laid out the rules that they have personal jurisdiction, so that she can then point out, the nonsense that he's saying. It comes across to her as nonsense because obviously she has personal jurisdiction and subject matter jurisdiction. So then he's saying, well, I want to be, she's claiming that he's saying that he wants to have an informed information or whatever, which will come across as nonsense, because it doesn't exist within their legal system, so they can't recognize it. So at the points, those, when she was laying out all of those codes, that would have been a great time to just interrupt her objection. Do you have any factual evidence that those codes apply to me in the first place? So, and if one were to sit down and read the specific codes that she was citing as personal jurisdiction, I'll bet that hidden in that language somewhere is this idea that people are consenting when they show up, when they are served a document and then they respond to it and show up and do this sort of stuff. That's what gives them personal jurisdiction, because they see that as you agreeing to it. So if he had challenged the notion that those statutes give that court personal jurisdiction over him, then there probably would have been more effective dialogue, and it might have ended up with her running off and rescheduling the hearing and trying to clean up some things. But right now, all she's doing is sweeping the floor, sweeping all the dust away, all the possible healable errors that might have been created along the way. She's just cleaning all of that up and making a nice, concise package so that she can force him to, persuade him to enter the guilty plea that she ends up persuading him to enter. Go ahead.
About his plea. The court finds that the defendant is being disorderly and disruptive, in the sense that not specifically with respect to his behavior, but with respect to his persistent failure to comply with court orders, and that the court finds that the defendant's conduct is extreme, in that he is making circular arguments that the court has already ruled on.
Go ahead and pause. So here, what you notice is she's actually, like, if you listen to her voice, and I'm kind of curious to see what it was like to be in the room with her, because I have a feeling she was kind of looking sideways at him at times, just kind of in anticipation that he would stop her from speaking or interrupt her, because she's putting a lot of things out there and she's leaving enough pause to where he could object if he wanted to. He could voice his objections if he wanted to. And as he continues to not do so, she just adds more and more things. Oh, he's making circular arguments, where he could be pointing out how it is that she is the one making circular arguments. So that would have been very beneficial if he had built the foundation this whole time that she was making the circular argument that just because the code says it applies to him, then he might not have found himself in a spot where she was accusing him of making circular arguments, because he sort of is, because he's not right now at this moment, he doesn't have a clarification on the table. And he's just keeps saying, I want to be informed, but he's not indicating what he wants to be informed of. He's just saying, I want to be informed before I enter a plea. Okay, well, you've been informed, and I've even given you the opportunity to tell me how it is that you would like to be informed. And he's saying, well, I just have some clarifications and I want you to give me honest responses. So he just keeps on asking to be informed rather than having something on the table that he wants to be informed about. Go ahead.
And the court finds that the defendant's conduct is offensive to the authority and dignity of the court. I will, Mr. Nesbitt, give you an opportunity to make a statement in mitigation, but otherwise I'm going to hold you in contempt of court, and these proceedings will come to an end. Anything you want the court to know, Mr. Nesbitt?
I just wanted to say for the record, I am still intent on putting in a guilty plea once I'm informed of the cause and nature of the charges.
Okay, so the record should reflect that Mr. Nesbitt...
I'm not refusing to enter a plea of guilty.
All right, stop there, right there, Mr. Nesbitt. The record should reflect that Mr. Nesbitt withdraws his not guilty plea and pleads guilty to speeding 20 to 24 miles over the speed limit, which is
Okay, go ahead and pause. So what she does there is you'll notice that she says the record reflects that blah blah blah. And this is something that judges commonly do. Record reflects that blah blah blah. And more of us need to be doing that as well. The record reflects that the judge is, engaging in circular arguments and is, this is assuming that he has laid the foundation, which I would say he has not done in this circumstance. But had he been laying the foundation, let the record show that the judge is making circular arguments. Let the record show that the judge is proceeding without there being any indication of evidence of jurisdiction at all. Let the record show that the judge is ignoring the fact that I never entered a not guilty plea, and that the not guilty plea was entered by a judge in order to alleviate the prosecution's burden of proof. Because let the record reflect that yada 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 is a precursor to an action. It's how they're basically, like, if this were a play or something, they're breaking the fourth wall, and they're speaking to the audience now to let the audience know why something is happening. And so we need to do that as well, because that is a thing that it then kind of forces the judge to respond to it. And if they don't respond to it, then that's there on the record, and the record will reflect that, and everybody who reads the transcript will see it. But if they usually, if it's something damning enough, they'll want to respond in some way, and it reopens dialogue. Here the magistrate puts herself, or the judge puts herself in a kind of a tough spot, because she calls in the sheriff, holds him in contempt, and then lets him know that he'll have the chance to speak, because she has to. Because at this point, he hasn't really done anything that would warrant contempt. But if she allows him to speak, then it's most likely that he will show why he should be held in contempt, or he'll bring up something which is completely irrelevant to what is going on. And then so she puts herself in this tough spot, because she's threatened him with contempt, doesn't really have a good enough reason to do so. It's just she's using it as a scare tactic. And so I think she recognized how sloppy it all came together. So once he said the words, "I'm not refusing to plead guilty," and, well, first he says, "It's my intention to plead guilty," like I've said, and then, "I'm not refusing to plead guilty," now it's really easy for her to say, well, let the record show that he's pled guilty. And then, of course, she silences him so that he won't go on and be able to show why the record should not reflect that. He and he should be objecting here pretty heavily. I mean, the problem with objecting here pretty heavily is that it might end up getting you held in contempt. So maybe it was better that he just allows her to do this. Who knows? But I think we're almost done. So go ahead.
So I accept his plea of guilty, and
Let the record reflect I did not enter that plea.
And the fine is $160 plus court costs, so that's $206. And we'll get your pay slip to that effect. Mr. Nesbitt, do you have any questions?
Yes. Are you entering the plea based on evidence, or are you entering the plea based on your own opinion?
I'm entering. I didn't enter the plea. You entered the plea. You said you
Objection. I did not enter the plea.
You said you wanted to enter a plea of guilty. So rather than
Objection.
holding you in,
I did not enter the plea of guilty.
Rather than holding you in contempt, unless you keep proceeding like this, I'm going to just accept your plea of guilty and impose the fine. So have a seat, and the clerk's going to get you a pay slip.
Okay, go ahead and pause. So there was the threat of violence. Now, one of the things that I obviously would have done, because I have, and a lot of people may think it's silly, but have her clarify what she means by the fine, have her clarify exactly what she is saying this punishment is, because it is cruel and unusual punishment for her to require you to contract with a third party in the hopes that they will give you these things called USD Federal Reserve notes so that you can give them to the court. And in fact, that type of thing is considered unconstitutional to them. So having her clarify what she means by a fine, just because they issue the punishment doesn't mean that you're informed all of a sudden and that you don't have clarifications anymore. You could just as easily still continue to ask, well, wait a minute, I was first forced into an arraignment hearing where a judge entered a not guilty plea in order to alleviate the prosecution of their burden. And then the second judge called it a final hearing and accused me of entering a not guilty plea when I hadn't, and then threatened me with violence to get this guilty plea. And then she said that I have to pay this fine. She refused to clarify what she meant by this fine. So now I'm asking in writing, can you please explain to me what you mean by such and such dollar fine? And also, can you show me any factual evidence that I have an obligation to carry out this punishment, or to carry out this sentence? And there's no reason to stop at that point. You certainly you can use their appeal process, but keep in mind that you may not succeed there. But even if you don't succeed, then that doesn't make the question go away. That doesn't make the clarification go away. Get them to threaten you with violence before you give them anything, and then once they've taken it, file a claim of some kind against them, then go after them somehow. Go ahead.
Plea of guilty and impose the fine. So have a seat, and the clerk's going to get you a pay slip. And you're excused, officer. Thanks.
Can I get some documents for the appeal, if you don't mind?
We will get you a pay slip and information on where you can go to appeal.
And also the transcript of the proceedings.
Okay, so that you have to order and pay for.
So I have to pay to get justice? Is that
have
is
a
that
seat,
what
Mr. Nesbitt. Have a seat.
Go ahead and pause. So don't allow a judge to just say, have a seat, have a seat. When you have a question, when you have a clarification, get the answer. Or say, are you refusing to answer? Let the record show that the judge is refusing to answer this question of whether or not I have to pay to get justice. Why do I have to be further injured in the hopes that justice will be served today? Oh, why are you telling me to sit down when I just asked you a question? You asked me if I had questions. Are you now going to threaten me further with violence to sit down when you asked me to ask you a question and I've just asked you a question and now you don't want to answer it because you don't like the question? Don't let them get away with this crap. This is crap that they're getting away with that nobody should be allowing them to get away with. Point it out. Go ahead. I think it's over, right?
Yeah, I think it's pretty much done.
Okay. Yeah, so I don't know if you guys have any questions or anything, but yeah.
Well, I'm just gonna chop that right there.
Fucking vodka, man.
Yeah.